Before we begin, remember that this video is for educational purposes only and isn't legal advice. Case summaries are meant to support your study, not replace reading the full case. This is one of those landmark cases that shows up on the bar exam year after year. Have you ever wondered if a typo in an advertisement could legally force you to sell your entire inventory at a loss? Today, we're looking at the landmark case of Partridge v. Crittenden to explain why most ads are just invitations to talk, not binding promises, and how this protects your business from expensive mistakes. Alright, let's start with the real-world problem. This is the part that helps you understand what is actually going on before you spend money on legal disputes. Imagine you post an ad for a product, but realize you only have one in stock, yet 50 people want to buy it. If every ad were a binding contract, you would be in breach of contract for 49 of those people immediately. This case clarifies that an advertisement is usually just an invitation to may help with, meaning you're inviting others to make you an offer instead. In 1968, Mr. Partridge placed an ad in a magazine for Bramblefinch cocks and hens at 25 shillings each. The problem was that selling these wild birds was actually prohibited under the Protection of Birds Act. He was charged with offering for sales a protected bird, which led to a massive legal debate over what offering actually means in a business context. The core of the issue was a conflict between criminal law and contract law. While the government wanted to rethink the trade of birds, the court had to decide if placing an ad was the same as the legal act of offering. If the ad wasn't a legal offer, then technically no crime had been committed under that specific wording of the law. The court ultimately ruled in favor of Mr. Partridge, deciding that his advertisement was an invitation to may help with and not an offer for sale. This set a huge precedent. Unless an advertisement clearly states it's a binding offer, the law assumes it's just the start of a negotiation. This prevents businesses from being sued for running out of stock or making simple pricing errors. Now that we know the story, let's look at the mechanics. Understanding this distinction is the best way to avoid a lawsuit when you're selling goods or services. The invitation to may help with rule exists primarily to protect sellers from multilateral contracts they can't fulfill. If you have 5 widgets and 1,000 people see your ad, you aren't legally forced to provide 1,000 widgets. The buyer is the one who makes the offer when they try to pay, and the seller chooses to accept or decline. The seller chooses to accept or decline. This principle also applies to items on a shelf in a store. When you see a price tag on a shirt, that isn't an offer to sell it to you at that price. It's an invitation for you to take it to the register and offer to buy it. This is why a store can technically refuse to sell an item if the price was marked incorrectly by mistake. Quick reminder, this is a study summary, not legal advice. Always read the full judgment for complete context and nuance. The rules from 1968 still apply today, especially in the digital world. Let's see how this affects your online store or service business. When you list a product on a website like Amazon or Shopify, the same rule applies. Your website is a digital shop window. The contract is usually only formed when the seller sends a confirmation email or ships the item, not the moment the buyer clicks buy. This is a vital safety net for technical glitches. We've all seen cases where a $1,000 TV is listed for $10. Thanks to Partridge v. Crittenden, the retailer can usually cancel those orders because the ad wasn't a binding offer. However, doing this too often can lead to consumer protection complaints, even if it isn't a breach of contract, so handle these errors carefully. In an auction, the request for bids is an invitation to may help with. Each bid is an offer, and the fall of the hammer is the acceptance. Understanding this sequence helps you know exactly when you're legally committed to a price, whether you're the buyer or the seller. If you ask 3 contractors for a quote, your request is an invitation to may help with. Their quotes are the offers. You aren't forced to pick any of them just because you asked for the price. This keeps the power in the hands of the person paying until a formal agreement is signed. To avoid the messy legal grey areas Partridge found himself in, you should follow a few simple best practices when advertising. Always include phrases like "while supplies last" or "subject to availability." While the law generally protects you, these phrases make it much harder for a disgruntled customer to claim you made a specific offer to them personally. It sets the expectation of an invitation to may help with from the start. Before publishing, check if your language sounds like a promise. Avoid words like may potentiallys or will sell to anyone for X. Stick to descriptive language and prices. This keeps your communication in the invitation category rather than the binding offers category. If a mistake happens, communicate immediately. Legally, you might be protected by Partridge v. Crittenden, but practically, offering a small discount or an apology can prevent a customer from filing a complaint with a regulatory body. Know your legal rights, but use customer service to solve the friction. While this case provides a general framework, specific situations might require a second look from a qualified legal pro. If you're dealing with real estate or high-value machinery, the lines between an invitation and an offer can blur during long negotiations. If the stakes are high, have a professional review, your heads of terms, to ensure you haven't accidentally triggered a binding agreement too early. Remember that while Partridge v. Crittenden protects you in contract law, bait-and-switch advertising is still lesser known under consumer protection statutes. If you advertise something you have no intention of selling just to get people in the door, you'll face fines regardless of contract theory. While this 1968 UK case is a cornerstone of common law, different regions may have specific statutes that override it, especially regarding online retail. Always check if your local laws have added strict liabilities for advertised prices before assuming you can always cancel an order. The takeaway is simple. Partridge v. Crittenden is the business owner's shield. It ensures that an advertisement is the beginning of a conversation, not the end of a legal trap. Use clear language, manage your inventory, and you'll stay on the right side of contract law. That's the practical version of what matters most. The big idea is to understand the problem, compare the right details, and avoid rushing into an expensive decision without context. If this helped, like and subscribe for more practical guides that help you compare costs, understand quotes, and choose the right pro with more confidence. Share this with a study group or anyone preparing for the bar exam. Thanks for watching. Remember, this is educational only. Read the full case and consult your course materials. Subscribe for more case summaries.